in this particular case, they're telling him, you must take down your dam under our supervision, do it the way we tell you to do it, which is going to be a very costly procedure, I'm sure.
Yes.
They want to avoid any more yellow rivers, I suspect.
That'd be good for them.
So it's going to be very costly to do. And then if you want to build your pond after you've dismantled it, rebuild it, then you have to apply for a permit with the Army Corps of Engineers. Those permits cost, what, a couple $100,000?
Yeah.
In environmental studies, this, that, and the other thing. It's, they're essentially trying to make it impossible for farmers like Andy Johnson to build a simple stock pond to water their horses and cattle.
Yeah, the federal government has unlimited resources, so it's trying to use those resources to bankrupt ordinary Americans so that they don't have to comply, so that the EPA doesn't have to comply with the law.
Now, answer me this. Why would the EPA, I mean, this is obviously a case where the optics are not in the EPA's favor. This makes them look like the overbearing bullies that they are. Why would they go after a case like this? Are they trying to establish the precedent that says, hey, if we can run over this guy, we can run over anybody?
That was really the only explanation I could come up with. It really makes no sense. If the government here is really trying to do the right thing, they would follow the law and allow Andrew Johnson to build a stock pond, which happens to help clean the environment, a goal of the EPA, but rather they're trying to assert their dominance over the fact, I'm guessing, that the state gave its thumbs up and the EPA probably felt that it was coming onto their territory.
So it's a turf war between the state government and the federal government to a certain
I'm
extent.
speculating, but I could certainly see that.
Yeah. Okay. Well, let's move on to the Kent recycling case. How does that relate? That's a
Yes.
case of prior converted croplands. What in the world is that?
So the prior converted croplands, basically, there were properties that wetlands arguably developed according to the Army Corps of Engineers, and they made the determination that the property in Kent Recycling down in Louisiana was indeed a wetland. And so the property owners at the time, they wanted to challenge this ruling right away. The jurisdictional determination is the legal term of whether or not it was indeed, the Army Corps of Engineers can make this determination. Mm-hmm. But the Army Corps of Engineers pretty much said that Kent Recycling has to go through all these other procedures that Richard just described beforehand, in similar to the Andy Johnson case, before they could get access to federal court. Now in Kent Recycling, the court said that yes, indeed, you do actually have to go through all these procedures before you get access to federal courts. However, another case, the Eighth Circuit, Hawks, the court came into the opposite conclusion. Now, Hawks is another PLF case, so this actually sets up a very interesting circuit split here. And we have filed a petition for review at the United States Supreme Court for Kent Recycling, and the government has filed for a petition review for the Hawks case in the Eighth Circuit. So it seems very likely that the court is likely to hear either one or both of these cases this upcoming term. Now, the first conference for the Supreme Court to determine new cases just occurred today, or this past Monday, and they released a couple cases that they will be hearing today. Kent Recycling wasn't on there, but we're still optimistic that it will be heard.
I think this just underscores the important work that PLF does. I don't think the average citizen is aware that the federal government is walking around telling property owners, you have to do this and you have to pay for it. And then after you're done paying for it and abiding by our regulations and our dictates, then you can take us to court and fight for your legal property rights.
To do it the right way in the first place.
Yes. Yeah, to build a pond, to go fishing with your daughters and provide clean downstream water. Like, you actually have to spend millions of dollars, follow their dictates, and then you can challenge them. That's the way they want you to do it, and it's just contrary to liberty.
So yeah, the whole irony in it too is like all these. We're just trying to get access for people. We're trying to get the EPA to follow the law here, but they're trying to shut people out of court, which doesn't sound very democratic, doesn't sound very American. And also, one of the issues we have right now, too, with the EPA is the fact that they have, they've overstepped their bounds here, and we'll see how it goes.
Another area of law away from the environmental, but into another important part of the whole economic and personal liberty environment in the United States is racial preferences. In California, we've got Prop 209, which ostensibly says that the state and state universities, et cetera, cannot discriminate on the basis of race. In Texas, it's a little bit different situation, and the case there is Fisher versus the University of Texas. Tell us a little bit about that case and its many trips to the U.S. Supreme Court.
So this is a fun case. PLF has been involved in this case pretty much since the inception, and the brief we just filed in the United States Supreme Court as amicus on behalf of Abigail Fisher is the 8th brief that PLF has filed on behalf of Ms. Fisher in this case. So the University of Texas had a racial preference program back in the 90s that was struck down by the Fifth Circuit. However, in 2003, the United States handed down a case called Grutter versus Bollinger, which said that universities are allowed to use racial considerations for narrow purpose of creating diversity in the classroom. And so a lot of these colleges and universities have taken that ruling and just completely ran with it. So the University of Texas instituted a 10% plan, which said that the people who finish at the top 10% of their high school class in the state of Texas gain admission to the University of Texas. But for the other spots, for the students who don't finish in the top 10%, they are judged on another basis too, and part of the consideration is race. And if you're Latino or African American, you get a preference in the University of Texas system. And we're arguing on behalf of, on the side of Abigail Fisher, that this is plainly unconstitutional, that the government cannot be considering race when it's making these type of decisions. So it's not exactly clear what the Supreme Court's going to do with this case. This is the second time this specific case is in front of the Supreme Court. The first time it was in front of the Supreme Court, they said that the lower circuits failed to consider the case under what's called strict scrutiny, which is the highest level of scrutiny a court can give to a specific law, and it's supposed to construe everything against the government and have the government really justify every action it takes. And it said that the lower courts didn't do that, so they sent it back to the lower courts. And the lower courts last year in the Fifth Circuit said that the University of Texas racial preference program passes strict scrutiny. So now it's back to the Supreme Court, and it's a bit unclear what they're going to do. They might rule on the case narrowly and just say that the University of Texas's use of race in this specific instance is unconstitutional. It may then also say that the use of race generally in college admissions is unconstitutional. It's not completely clear, but that's the current state of that case.
And what's your role in that case?
I've written a little bit about this. I wrote a blog post last week on this issue. I argued that in the University of Texas system and the state of Texas is kind of interesting. So one of the rules about racial preferences or using race for university admissions is that you can't racially balance your college population based on the state population. So when you look at the state of Texas, it's kind of interesting. So up until this last school year, there were always more Latino students than Asian students. But Latino students continued to get racial preferences while Asian students did not. And when you really consider the evidence, really the only explanation is that they're trying to racially balance. Now, Asians make up 4% of the state of Texas, but made up roughly 18, 19%, or that's not correct, about 15% for a certain time of the state, the population of the University of Texas, Austin, while Hispanics and Latinos, who make up roughly 36 to 37% of the state of Texas, only made up 18, 19% of the student body. So it's kind of curious at this point, why are we continuing to give racial preferences if the reason why we're allowed to give racial preferences is for the diversity purpose?
Yeah. Since we're on Libertarian CounterPoint, I figure I should give the libertarian argument to this. By granting somebody a preference based on the color of their skin, you are denying somebody else that very same opportunity because of the color of their skin. And racial preference programs are just, it's flat out racism. And I think the United States needs to move past this and stop looking at people as the color of their skin and start realizing that people are beautiful and creative individuals. And then it doesn't matter what their skin looks like. And honestly, it's a little shameful that government is walking around saying, okay, you are Latino, so therefore you have preference over somebody who's Asian. But maybe that Asian person worked a lot harder and they have better grades. Or maybe the Asian person gets preference over somebody who's Caucasian. And that Caucasian person worked a lot harder and has better grades. So I think the PLF is doing good work. Definitely need to try to move past this in America. I think it's more than just a political issue. It's a cultural issue. We need to stop looking at skin color and realizing that diversity is about life experiences, not just, you know, what your birthday suit looks like.
Yeah, Chief Justice Roberts had a line in his opinion in Parents Involved a couple years, about a decade ago now, that said that the best way to stop discriminating on the basis of race is to stop discriminating on the basis of race. So
yeah,
hopefully the Supreme Court could take that up this term.
And maybe he'll follow his own precedent. Another interesting case that I think you're involved in is on an amicus basis is the Fredericks case, which is a case about high school, public school teachers being forced to pay the political portion of union dues.
Yeah, so actually I haven't really been involved in this case yet, but so Rebecca Friedrichs is a high school teacher in, I believe, Orange County. I might be wrong about that. But she's basically challenging whether or not she has to pay, whether she has to opt in or she has to affirmatively opt in, or does she have to opt out in order to pay her union dues that go towards political speech. Currently, the rule is you have to affirmatively opt out. So a couple years back, in a case called Knox versus SEIU, a case which PLF was an amici to also, we were the only group that wrote that you need to affirmatively opt in to pay these dues, and the court made that suggestion for mid-year payments. But this case deals with at the beginning of the year, so we're saying that, again, you have to opt into these payments before you make political speech, because there are certain issues when you're forced to affirmatively opt out of the payments. It's, one, harder, it takes your time. You have to actually go out there and say, I don't want to participate in that political speech, where that isn't where the assumption should be. Also, it raises the risk that you're going to be stigmatized by your colleagues if you actually go out of your way to say, I don't want to be involved in the union. And no one should have to have fear about exercising speech. That's a fundamental right guaranteed by the First Amendment. And we hope that the Supreme Court this term recognizes that and vindicates Rebecca Friedrichs' rights. Yeah.
Okay, and one more fun case very quickly. In Seattle, they're inspecting garbage to make sure that 10% of your garbage isn't food under pain of a $50 fine. PLF is fighting that.
Yeah, so this is a direct representation case coming out of our Pacific Northwest office. Currently, Seattle has, as you explained, Richard, a program that requires you to compost at least 10% of your waste, otherwise you're subjected to fines. And this allows the city to snoop through your trash, and we think that's plainly unconstitutional under the Washington State Constitution. Unfortunately, the federal Constitution actually allows you to go through trash, but we're hoping to vindicate citizens of Seattle's rights.
Well, good luck on fighting the trash police.
Yeah.
That's the show for this week. We will be back again next week on Libertarian CounterPoint. And just keep in mind that we're on YouTube, we're on streaming live on accesssacramento.org, and of course on Channel 17 in Sacramento and other cable channels all over the place. Check our local listings for time and channel. Thank you very much. See you again next week.